Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video and podcast. Today I want to talk about a new decision by the Patent and Trademark Office's Trademark Trial and Appeal Board. And I have the opinion right in front of me, so I'm going to be referring to it as I talk about it because I think it really illustrates a lot of important issues that people need to be aware of if they're interested in filing for registration for trademarks and wanting to protect their trademarks from their competitors. And so let me just kind of start. This is a decision that came out on July the 2nd of 2021 from the Trademark Trial and Appeal Board. Now let me just kind of stop for a second and talk about the Trademark Trial and Appeal Board. When you file a trademark registration application, it goes to an examining person, trademark examiner in the USPTO, to review your application and make a determination as to whether to proceed with the registration of your trademark. And on occasion, the trademark examiner will come back to the applicant for the trademark and maybe have some insubstantial, non-substantive things that need to be changed on the application in order for registration to proceed. Those are typically called non-substantive office actions. Occasionally, the trademark examiner will come back with something more substantive, more important, more weighty, that goes to the very heart of whether or not the applicant is going to get a registration for their trademark that they filed. These are called substantive office actions. And one of the most common substantive office actions that causes a blip or a problem with registration is a office action based on Section 2D of the Trademark Act. And what that is the examiner has made a determination that the applied for trademark is confusingly similar to another registered trademark already on file with the USPTO. And so because the trademark examiner has made a determination that a particular applicant's trademark filing is confusingly similar to an existing registered trademark, they will come back and say that at this point it appears they will not be able to get you will not be able to get your trademark registered. And you can, if you're in that situation, you can try to ask the Trademark Act examiner to reconsider. You can file essentially a legal brief with the trademark examiner in response to their office action, explaining why the examiner is wrong, and there should be no confusion in the marketplace because your mark is not confusingly similar to another mark. That is the first step when you're met with a substantive office action based on Section 2D of the Trademark Act. If you do that and the trademark examiner comes back and says, no, I don't agree, you haven't convinced me, the trademark that you're applying for is confusingly similar to another registered trademark, then your next step is to appeal that decision to the Trademark Trial and Appeal Board. Now, there's a recent case that I want to talk about today that kind of illustrates very well what happens when you do make an appeal to the Trademark Trial and Appeal Board based on an office action that comes out of or is grounded on Section 2D of the Trademark Act being confusingly similar to a registered trademark. And this is the case involving a trademark application filed for the trademark Forage, F-O-R-A-G-E, Forage Kitchen. Now, in that case, the trademark applicant sought a trademark registered trademark for its trademark Forage Kitchen in the International Class 43 for restaurant services. In other words, it was going to have a restaurant called Forage Kitchen. The applicant, either on when it filed its application or after being asked to do so by the examiner, it's not clear in the decision, disclaimed the term kitchen apart from the mark. In other words, the applicant was not claiming any trademark in the word kitchen apart from the overall trademark Forage Kitchen, which is that's common and expected in a trademark application that has a generic word like kitchen in the trademark. So that's all good and well and good. But the trademark examiner said that unfortunately there was an existing trademark that had already been registered in the USPTO for the mark Forage, spelled Phorage, Forage, and that was for the same class, International Class 43, and that particular mark was for bar and restaurant services. And so because the examiner determined that Forage Kitchen, Forage, was confusingly similar to Forage, Phorage, and they were both, one was restaurant services, the other was bar and restaurant services. The examiner said too similar, confusingly similar, you cannot get your registration. So the applicant appealed to the examiner, requested reconsideration. The examining attorney denied that reconsideration, and the applicant appealed to the Trademark Trial and Appeal Board. And the case that just came out in July the 2nd, is a discussion of really the whole concept of what is confusingly similar between trademarks, particularly when you have a case where they sound the same, but they have other differences. So the Trademark Trial and Appeal Board first started with the premise and the statement that when they make a determination about likelihood of confusion, they look at all the facts and evidence that are relevant to what are called the DuPont cases factors. Now, without going into all the detail to describe all the factors under the DuPont case, it's important just to know that when the Trademark Trial and Appeal Board looks at these cases of whether trademarks are confusingly similar, they look at the DuPont case and these DuPont factors. But some of those are discussed in this case. Well, we'll get into those a little bit. They did start off by saying when you have a case where there is potentially a likelihood of confusion between trademarks, the two key considerations for the Trademark Trial and Appeal Board are, one, how similar are the two marks, and how similar are the services or goods for which the marks are being used to identify them. So you look at what the applicant and the one who has a registered trademark already, what services they're providing or what goods they're selling. How similar are those? That's one thing. And then you look at the similarity of their two marks. Those are the key things that you look at in this kind of analysis. Now, in this case, the Trademark Trial and Appeal Board noted that the actual services provided by both the applicant for Forage Kitchen and the registrant for Forage, Phorage, were essentially the same. They said they are in part identical. And so after having determined that, the board said, well, since that's the case, registration would have to be refused if the applicant's mark is likely to cause confusion with the registrant's mark, since they are in the same service area, the same category of services. Especially here where the applicant and the registrant services are essentially identical. The board said that they had to presume that the channel of trade and the classes of purchasers for the two services. In this case, the restaurant services for Forage Kitchen and the bar and restaurant services for Forage were the same. So, having determined that, the board had to go on to look at some of the other DuPont factors. Now, one factor that they focused on was factor number 6 in the DuPont case, which is whether or not the number and nature of similar marks in use for similar goods and services. Now, the applicant in this case, Forage Kitchen, brought this factor up and argued that since there are a lot of businesses in the restaurant service area and in other food service area and food preparation and distribution area, since there are a lot of businesses that use the trademark Forage, Forage, that this was essentially a very weak mark that Forage, Phorag, had. And because of that, the scope of their protection in this matter should be lessened because of the weakness of their trademark. In doing so, in making this argument, the applicant brought forth a number of bits of evidence showing a lot of different businesses that use the word forage as part of their business name, as part of their trademarking, citing to a number of websites for different businesses. And then they also showed that there were a number of registered trademarks that used the term forage in their trademark already in similar service areas, in the food and food distribution and restaurant area. And based on that, the board determined that it really was a weak trademark that Forage, Phorag, had in this context because of the number of very similar trademarks being used in the marketplace using the word forage, Forage. Now that didn't end the analysis. That was just factor 6 in the DuPont analysis. And so then the board also looked at the similarity of the marks. In this case, the board determined that really the two marks sound essentially the same, even though they are spelled differently. Phonetically, they sound the same. You would pronounce forage in Forage Kitchen pretty much how you would expect to say the word forage, Phorage. And so that's a negative for the applicant since the marks sound the same. But they do appear differently because they're spelled differently, for one thing, and the applicant noted that the part of the word forage in Phorage, PHO is actually a common menu item in Vietnamese restaurants. It's pho, PHO, and there's like a great number of restaurants selling and marketing pho, and that in this case, having that word PHO, pho, in forage for the registered trademark actually indicated a difference between forage, Forage, which typically means you go out and look for wild, harvested, fresh items, and so there would be less likelihood of confusion between people in the marketplace between Forage Kitchen and forage, Phorage, because of the connotation that goes with pho in the name forage for the registered trademark. In addition, the applicant noted that because there are so many restaurants and food service businesses that have the word forage, Forag, in them, that really what people are looking at are to differentiate among the different businesses is what words go with the word forage. So whether it's Forage Kitchen, Forage Bakery, Forage Bar, Forage Pub, whatever, they're looking at that extra word. And in this case, you have Forage Kitchen, which is different than Forage, Phorage. So you have the vast number of businesses that have the word forage in them in the food industry. You have the fact that pho is a Vietnamese soup that is attached to the commercial connotation for the registered trademark Forage, Phorage, and you have the fact that Forage Kitchen has the extra word kitchen that is like all these other forage businesses out there that differentiate among themselves by adding another word like pub, brewery, bakery, kitchen. And so based on all those factors, the fact that you had all these other businesses out there, plus you had a number of registered trademarks using the word forage in the food industry, and then the fact that you did have pho as really a connotation that comes with respect to the registered trademark, the board determined that the refusal by the trademark examiner to allow the registration of the trademark Forage Kitchen was wrong and should be reversed, and there was not this likelihood of confusion between Forage Kitchen and the registrant Forage, Phorage. So that's good news for the applicant. This decision by the board allows them to go forward with their registration of their trademark Forage Kitchen. This case also demonstrates sort of the analysis that you have to go through in determining likelihood of confusion, the fact that you have to take into account sounds of words. You really have to look deep and long when you do a search at the very outset to make sure that you can lessen the likelihood you're going to run into a problem like a potential denial for likelihood of confusion if you know the landscape of what marks are out there before you get started. So anyway, I hope this helps. It's a very interesting case. I will probably link to this decision in a blog post that goes with this video, so if you want to take a look and read this decision, I think it's worth your time. It's not that long, and it's really quite interesting. So that's it for today. I hope this helps, and we'll talk to you next time.